Warm greetings everyone. I'm Dr. Purnima Khanna from Khalsa College of Law, Amritsar. Dear learners, today we will learn about a very important topic of family law, that is restitution of conjugal rights under Hindu law. The learning outcomes of the present module will be, firstly, we will learn about the basic introduction, then meaning and objectives of the remedy, then constitutional validity of Section 9 of the Hindu Marriage Act 1955, and finally the conclusion. My dear learners, let's begin with a brief overview of the topic. After marriage, a spouse has an entitlement to receive the society and consortium of the other spouse. A cause of action, therefore, arises when one of the parties to the marriage withdraws from the society of the other. Restitution of conjugal rights is a relief or remedy available to either of the parties to the marriage who got abandoned by the other spouse without explaining or giving any just and reasonable grounds for abandonment. Section 9 of the Hindu Marriage Act provides that when either the husband or the wife has without reasonable excuse withdrawn from the society of the other, the aggrieved party may apply by petition to the district court for restitution of conjugal rights. Now, let's understand the meaning of the term conjugal. Conjugal means relating to the marital state or emphasizing the relations between the two married individuals. Restitution of conjugal rights refers to the restoration of matrimonial rights of an aggrieved spouse. Consortium means companionship, love, affection, comfort, mutual services, sexual intercourse. All these belong to the married state. Taken together, they mean consortium. Restitution of conjugal rights means resuming the marital relationship between both spouses. The main objective is to consummate the marriage and get along with each other's society and comforts. The petition for restitution of conjugal rights is filed to make the court intervene between the parties to decide the case and grant the decree of restitution to preserve the marriage union. Now, let's have a brief discussion about the objectives of the remedy. Restitution of conjugal rights is a remedy that one person can avail of if he or she desires to give their relationship one chance to work out. Therefore, it is very important that there is a legal remedy in the law that could help a person in a marital relationship to live together where they can sort out their differences, give a chance to their bond, or come to a mutual understanding of whether they can live together in the future or not. Without giving that one chance, one person is left abandoned, unanswered, and without reasonable excuse. The sine qua non for maintaining an application under Section 9 is the existence of a relationship between a husband and wife as an admitted fact between the parties. It is only when the parties do not dispute the very existence of marriage between them, and when the relationship of husband and wife inter se is not disputed by both, that the aggrieved party is entitled to file an application for restitution of conjugal rights under Section 9 of the Hindu Marriage Act 1955. Now, what is withdrawal from society? In Shrimati Sushila Bai versus Prem Narayan, 1964, the court observed that long silence and unresponsive attitude and cold indifference towards his wife on the part of the respondent are sufficient to convince the court that it is he who has abandoned his wife without any excuse. A married couple has the right to enjoy each other's company and society. Failure to perform the marital obligation of cohabitation and withdrawing from the society of one's spouse without a reasonable cause is grave injustice. Hence, if one of the spouses withdraws from society temporarily with an intention to return to matrimonial home, it does not amount to withdrawal from society under Section 9. J.D. Main observes that failure to render conjugal duties, refusal to stay together, or marital intercourse with the other spouse would normally constitute withdrawal from the society of the other spouse. He further asserts the expression society used in this section should be understood as marital cohabitation. That is, the husband cherishing and supporting his wife as a husband should do, and wife rendering duties as a housewife, and does not necessarily imply a husband and wife living together physically for the purpose of sexual intercourse under the same roof. Though they may not live under the same roof, there would be cohabitation in the wider sense of the term if they fulfilled their mutual duties to each other as husband and wife. Now, what is reasonable cause? In Rajbala versus Devi Prakash, 1995, where the husband, a drinker and a gambler, wanted his wife to lead an immoral life, because of which his wife left him and went to stay with her parents, but was willing to return, provided he left his bad habits. A decree for restitution of conjugal rights could not be granted in favor of the husband. In Sapna versus Neetu, 2009, the wife was subjected to cruelty for dowry, and a criminal case was pending under Section 498A of the Indian Penal Code against the husband and his relatives. Restitution of conjugal rights cannot be decreed. Then, in Machumal versus Devibal, 1977, the court observed that if the wife leaves the husband because of his extramarital relationships with other women, she has a reasonable excuse to leave the matrimonial home and stay separately. In Shrimati Sandhya Bhattacharjee versus Gopinath Bhattacharjee, 1983, the respondent did not make any attempt to bring his wife back and also spurned his father-in-law's request for taking the wife back. He had, without any reasonable excuse, withdrawn from the society of his wife. And the court held that the wife was entitled to the decree of restitution of conjugal rights. Now, my dear learners, we must also know the meaning of matrimonial home. In view of the change in the social and economic life with the passage of time, there are occasions where both the wife and the husband have to earn their bread, sometimes working in different places. Such cases pose difficulty in deciding the question of a matrimonial home. In an earlier case, Tirath Kaur versus Kartar Singh, 1964, it was held that where the wife refuses to resign her job, which compels her to live away from her husband and join him, it cannot be said that she has not deserted him or has not withdrawn from his society without a reasonable cause, and that the application of the husband for restitution of conjugal rights cannot be dismissed merely because she has expressed a desire that the marriage should continue and also consented to visit the husband and to allow him to visit her occasionally. In Kailashwati versus Ayodhya Prakash, 1977, the appellant Kailashwati was married to the respondent Ayodhya Prakash, and at the time both were employed as village level teachers. The appellant wife at her parental village Bilga, Philor, and the respondent husband at village Kot Ise Khan. After the marriage, the wife was transferred to her husband's village, and they stayed together for 8-9 months. Later, the husband transferred the wife to her parental home, where she began to live with her parents. The husband filed an application for restitution of conjugal rights under Section 9 of Hindu Marriage Act. The legal issue before the court was whether a wife who was gainfully employed at a place away from her matrimonial home would be justified in law to refuse to leave her job and join her husband to live in matrimonial home. The husband alleged that after that, the wife willingly got transferred to her parental village and started living with her parents. He alleged that after her transfer to her parental village, except for 3-4 days, the couple had stayed separately. He further contended that he was able to maintain his wife in dignified comfort at the place of his posting, from his salary and earnings from agricultural land and other sources. He contended that for 12 long and best years of his life, his wife has denied him the society and sustenance of the conjugal life. And if she persists in her adamancy, there is little possibility of her returning home until perhaps her retirement from government service. The wife pleaded that she had never refused to honor her matrimonial obligations, but was not ready to resign from her job in order to return to the matrimonial home. She further contended that husband was aware of her job at the time of their marriage and accepted her as a working wife. She was under no obligation to leave her job in order to live with the husband. She asserted that she never denied access to her husband as and when possible in peculiar circumstances, and she never refused to go with the husband on holidays. The trial court decided in favor of the husband and directed the wife to return to her matrimonial home. The wife filed an appeal before the High Court against the decision of the trial court. The learned single judge upheld the findings and decision of the trial court. The latest patents bench held that if both parties agree by mutual consent, they may even live in separate countries for the purpose of employment without jeopardizing their marital obligations towards each other. Perhaps the time has come when the appellant must make a choice between the job and the husband. A unilateral withdrawal from the society of her husband in the present situation cannot possibly be deemed a reasonable excuse so as to come within the ambit of the definition provided under Section 9 of the Hindu Marriage Act. The court dismissed the appeal of the wife and held that employment by the wife was no reasonable ground for withdrawal from the society of her husband and to leave the matrimonial home. The position emphasized in Tirath Kaur's case and Kailashwati's case was retreated by various high courts, which gradually liberalized their opinions on the same. In Shanti Nigam versus R.C. Nigam, 1971, The Allahabad High Court observed that in view of the altered social and economic conditions, both husband and wife may think it necessary to work and contribute to the family chest. It is one thing for a wife to say that she will not go to her husband and will not cohabit with him, nor will she allow him to come to her. While it is different if she says that it is necessary for the upkeep of the family that she should also work and she should go to her husband whenever it is possible for her to do so. And the husband could also come to her at his own convenience. As far as the burden of proof is concerned, the Marriage Laws Amendment Act 1976 added an explanation to Section 9, stating that a party to the marriage bears the burden of proof if they claim to have left the matrimonial home for a reasonable cause. In Shrimati Sushilabai versus Prem Narayan, 1964, the court observed that in order to sustain a petition for restitution of conjugal rights, it is necessary to establish that the respondent has withdrawn from the society of the petitioner. The society means conjugal society. Thus, the onus is on the petitioner, who can succeed only on the strength of his own case and not on the weakness of the defense setup. The explanation added to Section 9 by the Amending Act of 1976 has merely provided for a rule of evidence by laying down the burden of proof in regard to a question of whether there has been a reasonable excuse for withdrawal from the society of the petitioning spouse on the party pleading excuse. This burden of proof is very light since the spouses are always supposed to live together. And if he or she lives separately, it is for that person to prove the conditions that have necessitated such a course to be taken. Thereafter, that burden would shift to the other party to show that he or she has withdrawn from the society of the other for a reasonable excuse. Now, what is the mode of execution of this petition? If a respondent willfully fails to obey the decree of restitution of conjugal rights, even after having an opportunity to do so, the court may, in the execution of the decree, attach the property of the respondent. Furthermore, if within a year after such attachment the decree is still not complied with, the attached property may be sold, and out of the proceeds of the sale, the court may grant compensation to the petitioner as it thinks fit. Thus, it is clear that where the petitioner filing for the restitution is the wife, the court may order that if the respondent husband does not obey the decree within a specified time, the respondent shall pay such a periodical payment to the petitioner as the court thinks reasonable. My dear learners, the constitutional validity of Section 9 is very important to be elaborated here. In Swaraj Garg versus K.M. Garg 1978, the Delhi High Court remarked that there is no warrant in Hindu law to regard the Hindu wife as having no say in choosing the place of matrimonial home. Article 14 of the Constitution guarantees equality before the law and equal protection of the law for the husband and the wife. Any law which would give the exclusive right to the husband to decide upon the place of matrimonial home without considering the merits of the claim of the wife would be contrary to Article 14 and therefore unconstitutional for that reason. The court observed that there is no reason to hold that, whatever the circumstances, it is always the wife who must resign her job, however better it may be than the job of her husband, and must come to live with her husband even though the husband may not be able to maintain himself and his wife at the appropriate standard of living. The court allowed the appeal of the appellant wife and emphasized that at the present day, numerous women have taken up jobs to help their families and also to be useful members of society. It may be that the wife is financially and in other respects better situated to choose the place of matrimonial home than the husband. Then in T. Saritha versus T. Venkata Subbayya, 1983, Andhra Pradesh High Court, a civil revision petition was filed by Saritha, a well-known film actress of the South Indian screen, against an order passed by the learned subordinate judge overruling her objection raised to the entertaining of an application filed by one Venkat Subbayya under Section 9 of the Hindu Marriage Act for restitution of conjugal rights with her. One of the contentions of the petitioner wife was that Section 9 of the Act was violative of Articles 14, 19 and 21 of the Constitution of India. The court held that sexual cohabitation is an essential aspect of a decree of restitution of conjugal rights. The decree of restitution of conjugal rights transfers an individual's choice to engage in marital intercourse from the individual to the state. Forced sexual and consensual acts are both equally potent in producing offspring. The conception and delivery of a child involve the most intimate use of women's body. Restitution of conjugal rights constitutes the grossest form of violation of an individual's right to privacy. Article 21 of the Constitution safeguards the right to privacy and promotes individual dignity. Reproductive choice is fundamental to an individual's right to privacy. There is no overwhelming state interest that can justify violating an individual's constitutional right to privacy. The court observed that enforcement of Section 9 against an individual compelled her to have sexual relations with her spouse, thus depriving her of control over her body. This, according to the court, was a serious breach of the right to privacy, as it transfers the choice of whether or not to have marital intercourse to the state from the concerned individual. In Harvinder Kaur versus Harmandir Singh Chaudhary, 1984, the husband filed for restitution of conjugal rights, which was decreed in his favor. The wife appealed against the decree, in which the constitutional validity of Section 9 of the Hindu Marriage Act was challenged. The court held that under Section 9, the court has the power to make a decree of restitution of conjugal rights, which is the remedy available to enforce the return of a spouse who has withdrawn from cohabitation. The decree, if granted, orders the respondent to return within a period of 1 year to the aggrieved party. This period is specified in Section 13, 1A, subclause 2 of the Act. This remedy is aimed at preserving the marriage and not disrupting it, as in the case of divorce or judicial separation. Then in Shrimati Saroj Rani versus Sudarshan Kumar Chadha, 1984, in an appeal before the Supreme Court, the wife argued that Section 9 of the Act was arbitrary and void as offending Article 14 of the Constitution. The court held that in India, conjugal rights, that is, the right of the husband or wife to the society of the other spouse, are not merely a creature of the statute. Such a right is inherent in the very institution of marriage itself. There are sufficient safeguards in Section 9 of the Hindu Marriage Act to prevent it from being a tyranny. The Honorable Supreme Court held that Section 9 of the Act is not violative of Article 14 or Article 21 of the Constitution. If the purpose of the decree for restitution of conjugal rights in the said Act is understood in its proper perspective, and if the method of execution in cases of disobedience is kept in view. My dear learners, on the basis of foregoing discussion, it may be concluded that the matrimonial remedy of restitution of conjugal rights under Section 9 of the Hindu Marriage Act 1955 seeks to achieve the stability of marriage. It is a fundamental principle in matrimonial law that one spouse is entitled to the society and comfort of the other, and where one abandoned the other without just cause, the old ecclesiastical courts, upon the petition of the other, would grant a decree for the restitution of conjugal rights. The court enforces matrimonial cohabitation. The court cannot compel the duty of matrimonial intercourse, but it can compel matrimonial cohabitation. With this, we come to the end of today's lecture. Thank you very much.